Look, if you're charged with certain federal drug charges, the law states that you are facing a mandatory minimum 10 years in federal prison. For example, this love and hip hop star was charged with drug trafficking and he was sentenced to 97 months in federal prison. And this federal agent was sentenced to 10 years for aiding and abetting smuggling drugs across the border. If you Google federal drug trafficking sentences, you will find pages and pages of press releases of people being sentenced to 10 years to 15 years in federal prison. But one of my recent cases where my client was charged with drug trafficking offenses was sentenced to only 6 months in prison. So what was the difference between these examples? So when you're charged with a drug crime, the judge and the prosecutors are going to look at several different things when it comes time for sentencing. The only difference between the client I represented and these other examples was my defense strategy. So in the next few minutes, I'm going to tell you exactly how I got my client only 6 months in federal prison. My name is Diane Bass. I'm a federal criminal defense attorney, and I represent people who are either under investigation or have been charged with federal crimes. I recently represented an individual who was charged with aiding and abetting trafficking of large quantities of heroin. He was facing up to life in federal prison. His mandatory minimum sentence was 10 years. That means the judge could not go below 10 years unless certain things occurred. So my client worked for his brother, and his brother asked him to drop off a bag that happened to contain about $100,000 in cash. And then he also asked him to receive a package from an individual that he didn't realize had 20 pounds of heroin in it. My client didn't know what the money was for, and he didn't know what was in the box. Oftentimes, I find people end up in the wrong place at the wrong time or involved with the wrong people. In this case, it happened to be my client's brother. The dilemma was that if my client went to trial and lost, he was facing this crazy long sentence in federal prison. So I advised my client that if we went to trial and he lost, he was facing a minimum of 10 years in federal prison. He did not care. He insisted that he didn't know anything and he wanted to go to trial. One of the problems with his case was that he did suspect that there were drugs involved, so I could not let him testify in his own defense. And there was some other really bad evidence that came out during trial. Going to trial is always a crapshoot. You're putting your life in the hands of 12 strangers. In my experience, they are most likely always very prosecution-oriented, and they just want to go home. They don't want to spend the time that they need to spend to deliberate and go over all of the evidence to come up with the right result. Needless to say, we went to trial and my client was convicted. After trial, though, I got the U.S. attorney to agree to meet with him for what we call a safety valve proffer. He was honest with her. He told her he did suspect, and so she believed him and recommended what we call safety valve to get him below the mandatory minimum. She also recommended what we call a minor role adjustment, recommending ultimately a 57-month sentence instead of this 10 years. So minor role is used in cases like this when somebody plays a smaller part in the case or they're not as much involved as other people were in the case. Many lawyers probably would have just said, oh, well, he's facing the 10-year mandatory minimum, but I was not willing to give up on this client. When we met with the prosecutor, I argued with the U.S. attorney that my client was what we call willfully blind. He deliberately avoided knowing the truth about what was going on, but he did suspect that something was going on. So after the U.S. attorney recommended the 57 months, I submitted an argument to the judge in writing that my client had 4 children under the age of 11, 2, 4, 6, and 11. His wife was struggling financially, and she couldn't explain to the kids where their father was because they were too young to understand. It was devastating. In addition, I submitted at least 20 character letters from people who absolutely loved and adored my client. I also advised the judge that my client had been the caretaker for his mother, who had been suffering from many medical conditions. And finally, I argued what sentences were given to the other people involved and why my client should not be sentenced to more than what they received. When sentencing day came, I knew that the government was recommending 57 months, but I did not know what the judge was going to do. The courtroom was filled with at least 25 people, friends and family, all there to support my client. I knew I had argued the shit out of it in my sentencing memo and when we were arguing in court, but I still didn't know what the judge was going to do. The judge acknowledged every single one of my arguments and he agreed with them. At that point, my client had been in custody for 6 months and the judge sentenced him to time served. he went home that night. It was the best day of my career. So sometimes if somebody tells you that there is no other option, you're gonna get 10 years, that may not be true. Your defense strategy is really important, and a very experienced federal criminal defense attorney can work their magic and get you an amazing result, even if you've been convicted at trial. If you or a loved one are under investigation, or you have been charged with a crime or even convicted at trial and facing sentencing, please contact my office immediately so I can tell you about all of your options. Also, if you're interested in more content like this, check out my website and all my other videos. And thanks for watching.